Hearing in the matter of an application by Kevin Maguire for judicial review.
Yes, Mr. O'Neill.
My Lords, my Lady, in this matter I appear on behalf of the appellant with Ms Davis and the respondents, represented by Mr Schofield, QC and Mr Sayers. Lord, first of all, I have to apologise to the court. The electronic bundle has not been to the standard which one would have hoped in terms of cases before this court. And I think it came in late, the original electronic bundle not having been up to scratch. Even then, there are still some failings in that, with some pages missed out and some of the legislation. So my learned junior has been burning the midnight oil in copying any missing parts. We have hard copies and a memory stick which has any replacements of such things which are missing. It's primarily 3 parts of the legislation, but I wasn't going to be taking the court to them, so this is really for completeness sake, but I do have to apologise to the court for...
Well, that's very fulsome apology. I know that in my eyes this is a very serious misdemeanour.
I realise that, my lord, which is why I'm bringing it up.
You can make up for it by being economical in your presentation, because we've read your quite extensive case very thoroughly and with all the quotations. So we're confident that you can bring it home very much earlier than the period for which you have indented.
I was absolutely. That was the other matter I was going to say, my lord. Yes, the case is meant to be a one-stop shop with all the cases relevant.
Well, it
there.
Certainly has achieved that objective.
Might be flogging a dead horse, but there it is. So, Lord, in that case, I will. Although I've set down for 2 hours, I'll try and finish within the hour, perhaps.
Good, very good. Well done.
We might all be finished by lunchtime. In that case, my lord, if I just. Really adopting the case, really in a sense, what I want to do in the hour that I have is to perhaps answer some of the points taken against me in the respondent's case. But my initial response to that is that the respondents have effectively, or perhaps ineffectively, set up a series of straw men and have sought to avoid to actually answer the points which has been made in the case against them. So, first of all, they say this is a case about the mere designation of counsel rather than a restriction on the choice of counsel, and I will deal with that point. They also say that we are suggesting that the Northern Ireland Bar Council should not be permitted to regulate the Northern Ireland Bar at all, and that our arguments in some way bring the end to self-regulation. That is most certainly not our case. Our case is that self-regulation, of course, can and should be exercised, but it has to be exercised within the due limits of the law. They also say that the impact, if our argument is accepted in relation to the constitutional propriety of the Northern Ireland Bar, limiting the right to counsel of choice, would be to make all public authorities having to apply all qualified convention rights as if they were unqualified. That again is just not the case, and it doesn't follow at all from our argument. In fact, I say that these are non-points which can be disposed of relatively quickly. As I say, on the first point, this is not about mere designation, which is the line used by the respondents. It's about choice and effective legal representation. It's a right which is tied up closely with the right of access to the court and effective access to the court. As I say, we do not dispute that the Bar Council can regulate the profession of barrister in Northern Ireland, but that there are limits to that, and it is possible for that power to be abused in some ways. And as I say, on the third point about the implications for qualified rights, this case is about and only about the fundamental constitutional right recognised at common law of the right to choose one's legal representation from among those otherwise qualified and with rights of audience before the court in question, which is reflected in the terms of Article 6.3c. So that's the right that we're concerned with, none others, and that's what our arguments focus upon. As I say, from the exhaustive survey of the case law set out in my case, I set out propositions that can be derived from that, and I simply repeat those. That is to say that we can derive from both the common law case law and as developed in the light of the Convention, the principle that the right of an individual to defend himself in person or through the legal assistance of his own choosing is a fundamental constitutional right, and as I say, it's one closely allied with the right of access to the court and the proper administration of justice in accordance with the law, and that the right of an accused to choose his own counsel will be respected by the national authorities in the UK, both in respect of privately funded as for publicly funded lawyers, unless, and this is a test which has been articulated in the case law, particularly the case of Bothwell and Doherty's judicial review, in both cases in which Lord Kerr was presiding, that unless there are substantial reasons for concluding that the interests of justice require otherwise. So the embodiment of the idea of choice of representation is given a high value. Of course, it's not an absolute value. Of course, it might well be that certain restrictions among those who can be imposed, but it's got to be substantial reasons for concluding in the interest of justice that the choice of counsel will not be recognised. And because it's substantial reasons for concluding in the interest of justice that one might potentially restrict this right, I say that as a matter of the constitutional structure of the United Kingdom, that is a matter which only a duly authorised authority can do. In the first instance, that will be a court, because the courts carry the primary constitutional responsibility for ensuring fairness in legal proceedings. And it is only, as I say, unless there's other specific authorisation for another body, that might have any locus, as it were, to restrict this choice. There isn't any in relation to the Northern Ireland Bar, and we'll come on to that.
So your argument, in essence, is that the Northern Ireland Bar was incompetent to, the Bar Council was incompetent to impose restrictions on the manner in which an individual should be represented.
Yes, I say that they're acting ultra vires. They clearly have competence to produce disciplinary rules, but the rule which has been produced in this case and the manner in which it's been applied and interpreted has been goes beyond their constitutional role, as well as being in breach of fundamental constitutional right.
Right.
So, well, that's my first point.
Good.
I will come back and develop that, but this is my quick outline. And if it does have the competence, as we say in Scotland, ESTO, it has the competence which is denied. They haven't exercised that in a manner which has been justified by the requirements. I say that the proportionality test applies here, and one looks and applies the classic proportionality 3 or 4 stage test from Bank Millet. They just have been found wanting in this, in that they fail in all the tests which are there, and I've set out the reasons why also in the case.
Yeah.
In terms of, so that's my outline. I'll move now to the legal aid framework, because it is actually quite useful and important, I think, to understand just how it works in Northern Ireland. So, in terms of the legal aid framework, when we're talking about criminal legal aid, we're undoubtedly within the ambit of the constitutional right of an individual to defend himself or herself in person and through legal assistance of his choosing. And that, as I say, is a right common law, but one which is reflected in the Convention. Now, the legal aid provisions in this case can be understood as the state giving substance to that fundamental common law constitutional right, and separately as implementing its obligations as a matter of convention law under reference to Article 6.3c. So, First of all, if we look at the Article 29 of the Legal Advice and Assistance Order of 1981, I was just going to give reference to the MS pages, but that might be unwise. It's page, the memory stick, page 555, and it's at Volume 1, Tab 5 of the Authorities in the hard copy. I'm not going to labour over this, but at page 556, the regulation 29.2 makes it clear that a criminal legal aid certificate may be granted in respect of any person, and it's by the court. So the question as to whether or not legal aid, criminal legal aid, which is, say, free legal assistance in effect, should be given in any particular case is a matter which the court decides upon. We then have the 2012 regulations, which set out more precisely the machinery which the state has put in place for the delivery of that right to legal aid. And they're at tab 3 of the bundle, volume 1, page 521 of the memory stick. And the relevant provision is Regulation 4, which is reproduced at 522 of the memory stick. And really just taking that shortly from Regulation 4.1, first of all, that sets out again that the court shall assign an accused a solicitor who's practicing in Northern Ireland and willing to undertake the defence of legally aided persons after taking into account representations which the applicant may make. So we can see that balance has been taken here in terms of how this right is to be realised. The representations are made by an accused, and then a solicitor is assigned by the court. Then Regulation 4.2, saying the assisted person shall be entitled to the service of any solicitor assigned. Implicitly in that, it's got to be that the solicitor will act in accordance with the accused person's instructions. The solicitor is a law agent for the accused having been assigned thereto. Regulation 4.5a then tells us that the legal aid certificate, criminal legal aid certificate, automatically carries it with it representation for one counsel. So, with that representation for one counsel automatically being carried with it, Regulation 4.3 then allows a solicitor assigned to the case on behalf of the accused person, assisted person, to instruct any member of the bar. So again, we're back to, so this is where choice comes in again. The solicitor who's been assigned after hearing representations instructs counsel on the instructions of the accused. So choice is embodied in the regulation. And once they're assigned, then the counsel is entitled to be paid under the legal aid certificate by the state. That's Regulation 4.4. In exceptional cases, murder or cases of particular difficulty, the court again, and again, this is all the court and its rule, may certify that in its opinion the interests of justice require that in this case two counsel be instructed. And so that's Regulation 4.6, just says two counsel. And once there has...
Perhaps also bear in mind what's 4.3.
Yes. Yes, indeed.
Because 4.1 and 4.1 has to do with the assignation of a solicitor. 4.2, the services of the assigned solicitor. 4.3 permits the solicitor to instruct counsel and to counsel in a situation where a certificate's been granted under 5B, and 5B you took us to a moment ago.
Yes, and what 4.3 says that if the, so that's what I was coming on to that, my lord. Once you've got a certification for two counsel, you then come back and say, and you come to 4.3, and it says if you've got a two counsel certificate, you may instruct on behalf of the assisted person a member of the Northern Ireland Bar and a member of the bar who's either a QC practicing in Northern Ireland or a senior counsel practicing outside of Northern Ireland.
Yes, but the important part of 4.3 is that a certificate as provided for under 5B, one such member of the bar and a member of the bar being one of Her Majesty's counsel.
Yes, but it's a permissive provision, not
Well, is
direct.
it? That's what troubled me when I read it.
Yes.
If you notionally separate out the two halves of 4.3, you've got the first half which deals with a single counsel certificate,
Yes.
and the second half which deals with a two counsel certificate. Is that right?
Yes.
Okay. Now, if it's a single counsel certificate, who may the solicitor instruct?
They may instruct any member of the bar who's practicing in Northern Ireland and willing to appear as counsel.
Precisely. So the may is permissive in the sense that you can choose any one of the suitably qualified people.
Yep.
Is that right?
That's right.
Okay, now if it's a two counsel certificate, who then may the solicitor instruct?
He may instruct any member of the bar who's practicing in Northern Ireland willing to appear as counsel, and he may also instruct, again permissively, one of Her Majesty's counsel.
Yes.
But it's not saying he has to instruct.
Well, no, but the two who are dealt with by the second half of 4.3 are they not, A, any member of the bar, as in the case of a one counsel certificate,
Yes.
and two, any leading counsel, being one of Her Majesty's counsel or the Irish equivalent.
Well, that would certainly be one reading of it, and that's
Well,
the
that's
reading
why I'm
which is
asking
being-
you about it, because-
and I say that's, but that is not the reading which we contend for. One, because of the legislative history of this, and two, because we have the underlying constitutional principle, which is that one respects choice of the accused, unless there are substantial reasons.
But you are respecting choice, aren't you? He can have any QC he wants, just as he can have any junior he wants.
Well, I
Isn't
see
that it?
but in this case, but if that reading is such, in terms of the circumstances of this case, where the individual said, but I don't want a QC, I want an individual to lead my case because I know who and how that is, and he's being prevented by the reading of that rule and by the Rule 2011.
Well, this is all bootstraps, Mr. O'Neill. It rather assumes, I mean, that you may be right about that.
Yes.
If you are, then this rule doesn't say what it means.
Well, it does say what it means if it's interpreted in a convention-compatible
Right. Okay.
manner.
Anyway, that's how you put it.
Yeah, indeed, and again, in a manner which is compatible with the constitutional principle of allowing for choice, unless there are substantial reasons in the interest of justice to be otherwise.
If as you submit, 4.3 is permissive and it's not exhaustive, where do we find the provision which permits the solicitor to instruct people on some other basis?
To instruct which people on some other
Or
basis?
to instruct, for example, a junior leading a solicitor advocate?
Well, because he's entitled to instruct any member of the bar who's practicing in Northern Ireland willing to appear as counsel.
Yes, but the solicitor advocate isn't a member of the bar.
Well, this isn't about solicitor advocates at some levels, and this was a matter which was...
We'll stick with members of the bar. What's the provision that enables the solicitor to instruct two juniors?
He's entitled. He's been given a certificate which says simply for to counsel, and is then entitled to instruct to counsel, however that whatever counsel might be considered to be for the purpose of the regulation.
Unless 4.3
Unless 4.3
means
is written.
two counsel are one leader and one junior.
Yes, indeed, absolutely, and that's
Okay.
That's where this neat and narrow interpretation comes down to. And I say, well, no, that's not what the intention of the legislature was.
Okay.
And one has to look at that contextually, and it would not be in accordance with the choice of the accused in this case, and against the constitutional principle that the respect has to be given to the choice. Unless it's against there are substantial reasons.
So we read 4.3 as if it had at the end of it, or two such members of the bar, do we?
We read it against the background that there has been specifically left open in terms of the certification that something is required for two counsel, the possibility that leaves open those who are entitled to be heard before the court in question and are willing to act under criminal legal aid. But as I say, if we come on to the background to this, if we look at page 486 on the MS page, which is a letter from the chairman of the Bar Council of the 28th of March 2011 to the Northern Ireland Minister of Justice, and that's in the core bundle at page 486.
I think this is Mr. Ford's reply to Mr. Coulton, isn't it?
Yes, sorry, oh, that is right.
It's the reply you want, I take it, is it?
Yes, it's the reply I want, which is... and that says at the bottom of the page, requirement for written application for the assignment of two counsel will ensure that the court is fully apprised of all matters relevant to application. This assists the court in arriving at the right decision. In terms of the court granting a certificate for two junior counsel, I don't accept the assertion that there is no such practice or distinction in this jurisdiction, mentioning in the financial year the Legal Services Commission having paid out in a number of junior counsel cases. Having said that, I accept the representation made by you in your letter carefully, and accept it's more usual for defendants in two counsel cases to be represented by senior and junior counsel. In these circumstances, I've decided that the rules should limit the decision of the judge to granting a second counsel without being specific as to whether it is junior or senior counsel. And that's what's happened in this case. There has been no specification that it should be junior or senior counsel. Similarly, at page 488, which frankly is not the most readable in the hard copy, and I think we're going to have to produce clean copies of that. Apologies from that, but the relevant passage is also quoted in the case at page 99, MS page 99. This is a Justice Committee briefing from the Northern Ireland Courts and Tribunal Service on the 13th of October 2011, which mentions that page 489, and it really is not well.
Which paragraph?
It's the third paragraph in page 489.
Following the meeting, we made a further change, which is set out in the document provided to the committee.
And then following correspondence from the chairman of the Bar Council on 9th March, we made amendment to the rules to replace the words Queen's Counsel with Junior Counsel as a requirement of the ward to two counsel. The requirement is now just two counsel.
What's the status of this document, Mr. O'Neill, do you say? What is it?
It is a briefing document from the to the Justice Committee of the Northern Ireland Assembly. From the Northern Ireland Courts and Tribunal Service. And they're the ones who've changed, because what's happened has been a change in the rules from the previous specification that the court would award a certificate saying that there should be, in a two-certificate case, one Queen's Counsel and one Junior Counsel, just two counsel.
Well, in essence, your argument is that it was the government's intention that where a certificate was granted for two counsel, that should contemplate either senior and junior or two juniors, or indeed a junior and a solicitor advocate.
That is indeed what they say that their intention is doing.
Yeah.
They say that at page
The question may
490.
be whether Regulation 4.3 fulfilled that objective.
Yes, indeed, and that would be, if it doesn't, then it's a reading contrary to their intention, and I say contrary to the underlying constitutional
So
rights.
that's what it comes down to, really. That
That's
we ought to give Regulation 4.3 an interpretation which reflects the intention of the legislature as disclosed by these documents, and as which is in conformity with what you say is the convention right of the appellant.
Yes.
Have
And
you got
not
the old Have you got the old regulation, Mr.
sorry,
O'Neill?
no.
Have you got the old regulation that 4.3 replaced?
I'm not
Well,
sure.
don't worry if you haven't.
We don't,
But
but we
did
can
I
find
understand you to tell us that until the 2012 regulations, which are the ones that are operative in this case, are you telling us that the certificate for two counsel used to say Silk and Junior, in effect?
Yes, that's certainly my understanding, and that's why there's so much correspondence back and forth from the Bar Council saying that they object to this change, whereby the certification is simply.
But what exactly did they say? Do you know? All right. Well, you haven't got it. There it is.
Well, if we see, for example, page 277, which is the grant of the legal aid certificate in the present case.
Yeah.
And that's in the core bundle. That's from the County Court Division of Belfast, application having been made, charges set out. The court satisfied that he should obtain legal aid, gives the solicitor's name, and then I further certify pursuant to 4, 6 and 7, in my opinion, by reason of the case appearing to present exceptional difficulty, the interests of justice require that the defendant shall have the services of two counsel.
Yes.
And that's non-specified in terms of it being senior and or junior.
Which is what the rules now say, and that's the rules that he's operating on. That's your point.
Yeah.
Okay, right.
Yes. So
Your point is that District Judge Bagnall, I had thought it was Judge Philpott, but in fact it was District Judge Bagnall, didn't have any opportunity or didn't have any capacity to make an order other than two counsel.
yes, that's what's allowed for under the rules, and we see that from the application certificate, which is at page 274.
I mean, the practice in other parts of the United Kingdom may be entirely irrelevant, Mr. O'Neill, but if it is that certificates of this kind are commonly granted specifying Queen's Counsel and Junior Counsel, is that also a breach of the fundamental rights of which you speak?
It depends on what the application which is made. If on the instructions of the accused say that what I want is my existing counsel to be the leading junior, as was said in this case, the leading counsel in this case, then in other parts of the United Kingdom, I think in England, because my Leonard Jr. reminded me, that there are boxes as to what it is that you are applying for and what it is being granted under the legal aid certificate. So I can apply for a QC alone or two juniors.
If such certificates are granted in terms for Queen's Counsel and Junior Counsel, even if that is not what has been asked for, is that a breach of the
No, because
convention?
I say that's a decision by the court.
Because it's a court decision.
It's a court decision
Okay.
which is decided in the interest of fairness that is what is appropriate. And of course, there's a balance between those two.
Yep.
I just raise with you, out of fairness, Mr. O'Neill,
Yes.
your submissions rather assume that the word counsel can include a solicitor who has rights of audience.
That's certainly how the executive seem to be proceeding.
Yeah, I mean, there is a the terms counsel and solicitor are used in distinction from one another throughout these regulations.
Yes.
And indeed in the forms of certificate that can be granted as well.
Do the regulations use the expression higher court's advocate?
No, they don't, because
There's a difference between a solicitor and a higher court's advocate, isn't there?
yes, I think, and as I understand it, in Northern Ireland, I know that Lord Kerr can correct me on this, that solicitors had, as it were, theoretical rights of audience under the 1978 Judicature Act, but they only started exercising them really from 2005 when provision was made for their payment under the Legal Aid Fund, and that they exercised them as solicitor advocates in the Crown Court, but at the moment there are still no regulations giving them rights of audience in the Court of Appeal or in the High Court, and that matter's been kicked out for consultation over a number of periods. So at the moment, solicitor advocates, as I understand it, don't have rights of audience in the higher court.
Well, I think we so held, did we not?
Sorry?
We so held in the Court of Appeal.
Absolutely so. But he also held in Bothwell that if the interests of justice required it, then you would have no hesitation. But in the circumstances of that case, you held that these solicitor advocates had no experience in criminal appeals at all. But yes, but there was an inherent right under the Judicature Act of 78 to allow that. But so the matter is put out to regulation in other courts other than the Crown Court.
Right, well, the contours of this argument, I think, have been fairly fully explored, so shall we move on to the next one?
Yes, indeed. So on that issue, then, I think it's important, because we're talking about choice, just to highlight aspects of the facts. So the letter, first of all, the fact is a letter was sent, and that's at page 233, from the accused, saying in terms that he wished Mark Barlow, who's been his lead counsel from day one, he's been told that he's been informed by Mark Barlow he's no longer able to be my lead counsel, and I have to get a QC. He says, I've in terms had Mark Barlow, who did the last trial, as both my counsel, and I have total confidence in him. I only want him to present the trial. I've instructed my solicitor not to instruct another counsel, as I want Mark Barlow to continue to lead the case for me.
As a matter of curiosity, did Mr. Barlow appear on his final trial?
He did, yes.
By himself?
Yes, because otherwise he'd be breaching Rule 20.11. And that's one of the points which is being founded upon. Yeah. Because basically, as we'll come on and see, the Northern Ireland Bar says that despite the non-specificity of two counsel unspecified and the intention of the executive, that they apply the their disciplinary rules in a manner which achieves the end which they couldn't achieve by lobbying the executive in terms of specifying that it be Queen's Counsel. And we see that page 236. It's the letter in reply to the appellant of 4th November 2013, where it says they've made inquiries and inform you it would appear that you've been granted a certificate for senior and junior counsel to conduct your case. Now, of course, that's not what's been granted. It's been granted just to counsel. And then it says the ability of Mr. Barlow is in no way in question. Now, that's quite important. He's no way in question. However, your solicitor also applied for the services of a Queen's Counsel to act on your behalf. No, he didn't. He applied for two counsel. That would have required an application by a solicitor of the court. An experienced judge clearly deemed that you required a Queen's Counsel. No, he didn't. He said that this was required for two counsel and two counsel only. Only 1 in 10 barristers in Northern Ireland hold the rank of QC. This has not been availed of, and although Mr. Barlow can remain in your case as junior counsel and conduct the case on your behalf, you're entitled to his services and also Queen's Counsel. It is a matter entirely for you, should you wish to waive this entitlement, and I would expect that you your solicitor would inform the court of this should you intend to do so. So, basically what's being said is you cannot have, as you've requested, Mr. Barlow to continue to be your lead counsel and run this case. In terms of the two counsel who have been certified, he can either do it on his own, as he ultimately did, or you get a QC in whether you, despite the fact that you don't wish that to happen.
So Mr. Maguire's complaint is that he didn't, is that Mr. Barlow did not have the assistance of a junior. Is that right?
Yes, that he's the case is that the court has said this is complex and it needs two trial lawyers to use a neutral Americanish term, conducting the case. And the Northern Ireland Bar Council says, well, Mr. Barlow seems perfectly able, and if you really want him to run your case, then he's going to do it by himself.
Well, I expect the Crown had two counsel, did it?
I'll double check. We don't know, but we think so.
Really?
We don't. Well,
I'm sure it wouldn't be a given that there would
It
necessarily
would be astonishing, Mr. O'Neill.
for the Crown not to have to.
Not in Northern
No,
Ireland.
but for them to have to.
Prepare to be astonished, my lord.
Okay, well,
I think one has to leave one's presuppositions at the door once you cross the.
And a good thing too.
Yes, absolutely, my lord.
You don't even have to cross the
I'm
channel.
very sensitive in diversity
Advocates
and
depute
violence.
north of the border quite often don't have juniors.
well, what would be astonishing in England and Wales it was if there was more than one for the Crown. Absolutely out of the question.
Right.
Oh yes, there are sort of.
Yeah. Oh yes. Well, I apprehend-
Not the other way around.
And indeed, part of the complaints that the Northern Ireland Bar makes to is that we have to approach things with a devolutionist eye, I think is one of the phrases, and that things are different in Northern Ireland, and let's not just follow what they do in England where they're trying to cut costs. But there it is. It was certified as a two-counsel case. He was not able to, he either had to choose the one counsel he wanted or else bring in a QC. So basically, and that is a requirement not set out in the legal aid, in any regulations at all. It's a reading and enforcement of, as I say, achieving a policy which they couldn't achieve by way of the legislation by using their internal code of conduct. And it's a code of conduct which basically doesn't give any real weight to client choice. It rests on an a priori assumption and an assertion that in each and every criminally legal aided case, it's only in criminally legal aided cases, strangely, that the requirements of justice require that Queen's Counsel be instructed if it's a two-counsel case. If you were privately funding this, the rule wouldn't bite, partly the interest of
Well, is
client
there a
choice.
certification procedure in privately paying cases?
Is there what, sir?
Is there a certification procedure in privately paying cases?
I wouldn't, if you're not, you wouldn't go through this at all. But
Exactly.
but in terms of course. But my point is that the Northern Ireland Bar rules say that they say if a case needs two counsel, it's in the interest of justice that that be required to be Queen's Counsel. But they say in their rules, 2011. That applies only when it is a legal aid case in criminal matters. That somehow the interests of justice differ when it's a privately paying case where client choice comes in then. Now, it's not for the Northern Ireland Bar Council to decide when client choice is or is not to be given weight. But that is what they have asserted they have a right to do in this matter. We see this clearly if we just look at the transcript, parts of the transcript of the disciplinary procedure against Mr. Barlow, which begins at 345, but the relevant passage I want to look at page 356. The parties speaking here are Mr. Mark George QC, who's appearing in the disciplinary process on behalf of Mark Barlow and is questioning Ms. Christine Smith QC, who is the counsel appearing for the Professional Conduct Committee of the Northern Ireland Bar. And what is attempting to do is to work out precisely what the Northern Ireland Bar's understanding of 20.11 is, where it says, where exceptionally a senior counsel is unavailable, it's permissible for a junior to lead. So he says, on the exceptionality point, can I ask, one of the matters that Mr. Barlow will pray in aid is that his many years of experience of serious sex cases long before he was called to the bar in this jurisdiction. Must be plenty of seniors who don't have a wealth of experience of fraud or murder or all manner of cases, but might not actually have done a great deal of personal practical experience of doing sex cases as a category. Can I ask you on the exceptionality point, what is the position of somebody who's only a junior, they aren't a senior, but actually by comparison, that would stand comparison with many seniors, and actually, truth be told, they might not like to admit it, but truth be told, probably have more experience than some seniors. In terms, you've indicated the position of the Professional Conduct Committee in relation to the right of the client to choose counsel. If a client says, I'd rather have Mr. Barlow, albeit that he's a junior because of his experience, than to have a silk who is a silk, but seems to spend all of his time doing fraud cases, from what I can see from his profile, on the exceptionality point, there is no give and take there that somebody could in Mr. Barlow's position. And then the chairman interrupts and says, well, let's look at the actual wording, which is what actually Mr. George was seeking clarification on. The wording says, where exceptionally a senior counsel is unavailable, it's permissible for a junior to lead. And Mr. George says, I can see on the face of it, the provision seems to suggest the only exception can be made is availability and nothing else. And Ms. Smith says, that is the position. Can I just also, in ease of the situation, assure there's a substantial number of criminal silks in Northern Ireland who have a wealth of experience in dealing with cases of this nature? So George doesn't demur. And then they go on, if there'd been an attempt to assert availability and they were unavailable, we wouldn't be here. But he then asks, what if they actually had all been unavailable? And then the response is, well, that should have been indicated to the Professional Conduct Committee. And Mr. George says, we know that inquiry wasn't made. So his reading was the position that exceptionality in this context literally only means availability. Yes, it does, says Ms. Smith. There is no other criteria. Ms. Smith, yes, it does. The Bar of Northern Ireland, and this is the important one, can I say, take the view that if someone has attained the rank of Queen's Counsel, then they are capable of doing the job of Queen's Counsel in whatever forum they are placed. That's the a priori. It will always be better, no matter the experience of the counsel involved, to have a Queen's Counsel. There's something slightly Animal Farm about this. Junior good, silk, it's better.
Well, I'm not sure that Ms. Smith is suggesting that in every instance Queen's Counsel is going to do a better job than junior counsel. What she is saying is that it is a mark and requirement of the rank of Queen's Counsel that they be able to discharge their functions in whatever field they are briefed. That doesn't necessarily imply that there would not be more skilled senior junior counsel than senior counsel in a particular field.
But they wouldn't be allowed to lead, and that's the point.
No, well, that's, I mean, I think Ms. Smith isn't necessarily espousing that particular cause. But anyway, it probably doesn't matter what she says.
Well, what she says is the Bar of the Northern Ireland's view, that as she goes on, that's the reason, the rationale behind that rule, and why it isn't said that exceptionally where a senior counsel who's capable of running a sex case is unavailable. It's just being a senior counsel, because senior counsel will come in and do the job. But then, so that does trump client choice, says Mr. George correctly, does it not, so far as the Conduct Committee is concerned? The answer from the Professional Conduct Committee's point of view to a client who says, look, I've met Mr. Barlow, he seems to understand my case, he's got a wealth of experience. Your answer to that is he's not a senior, there are seniors available, therefore you have to get a senior rather than Mr. Barlow. And she says, unless you amend the certificate. What that means is, unless you go back and say, actually, although the court thought this was a two-counsel case, I've got a really good junior counsel with wealth of experience, I want him to lead. And they say, well, therefore, you've got to waive your right to two-counsel. So what that means is that the respondents have taken upon themselves a decision to reconfigure, effect a different balance of interests, give a completely different weight to client choice than is the intention of the executive and the wording of the legislation read against the background of the intention of the legislature and the fundamental constitutional recognition of a right to choose one's own counsel. among those who otherwise have the rights of audience.
Can I just go back a little bit? Because I think it was Lord Hughes was asking you questions about what might happen in England, where there might be a specification that it had to be leading counsel and junior counsel. Yeah. And you said if a court said it, it would be all right. And that sounds to me as if it then refines the issue that you have with this to the question of the competence of the Bar Council in Northern Ireland, rather than the action that they take, their competence to take it.
Yes.
Is that right?
That is right, and that's the first ground of appeal, my lady, in the sense that I'm
looks
saying...
as if it's only that, because you're not complaining of it in the event that a court does this. Well,
because that balance is one constitutionally which has to be struck by the governing authorities, which I say would be the court, because the court primarily has the control of and knows what is required as a matter of fairness, because it ultimately comes down to fairness in a criminal trial. But in this case, where what has been allowed for, against a background of allowing for choice of counsel, is that the Northern Ireland Bar has come in and used its disciplinary rules to shift that balance, to make a difference which discounts client choice. And that's what I say is problematic. It could be, of course, for example, and I don't exclude this, that institutions such as the Northern Ireland Bar were given responsibility in terms of legal aid. I mean, it was certainly what used to be the case in Scotland, that the solicitors, the Law Society of Scotland had responsibility for administering and awarding legal aid, I think actually between 1949 and 1987. So if the institutions of government have decided actually the most efficient way of doing this is to give the power expressly, then you could see that they might have that power. But in this case, that has not been done. And what the Northern Ireland Bar has done is use its disciplinary powers to effect change which has not been authorised to do. That's why I say it's not competent. And therefore constitutionally improper. But I accept that. Again, in the Scottish experience, it used to be that the Faculty of Advocates had a role in having counsel on the poor role from the 16th century onwards who were willing to act in criminal cases pro bono. And that was seen as them discharging a public duty. But we're not in that situation here because we have provision. The state has made provision for legal aid and has made those balancing aspects out. But it comes down to, I suppose, one of the issues is, and one of the confusions that seems to be arising in this case, and I'm going to be longer than an hour, I fear, at this rate, is the...
Not much.
Not much, indeed. I'll know when the bell rings. The respondent's obligation to respect convention rights. Of course, it's got a responsibility to respect convention rights, but that arises from the fact, and they seem to have lost sight of this, by being called a public authority under the Human Rights Act, that's not saying they have authority over the public, or that they are in fact an authority. What it's saying is that they have an obligation when their powers are exercised to make sure that they are exercised in a convention-compatible fashion.
Well, in some, your argument is that their status as a public authority does not invest them with the competence to make regulations, in effect, as to the representation of people who face criminal charges.
No, because because that's already been done by the competent authorities, and the competent authorities haven't, governing authorities. But yes, so they're a public authority because their decisions in disciplinary matters can determine the civil right of how barristers can exercise their profession. And that's your classic basis upon which they, as any other self-regulatory profession, are
just because they're a public authority, that doesn't enlarge the jurisdiction to make decisions.
It doesn't give them any rights, it just imposes obligations.
Yeah,
that's how it comes down.
And really, the whole argument rests on your first point about how you interpret the 2012 regulations. As if it's because you give them a wider interpretation, which you say is required in order to comply with convention rights, that you say they have a wider meaning than literally read they would appear to have. The Bar Council is effectively imposing a rule which reflects a literal meaning, but not the wider meaning, which you say has to be given, and so there's a disjunction gives rise to this problem of competence. Which
yes, and it's not just the convention right aspect, but we've seen the intention of the executive in changing matters.
Well,
to make this open. So that's the issue. You're a public authority because you, vis-a-vis barristers, can determine their rights and how they apply they exercise their professions. That's Article 6. How then are their convention rights engaged in this case? And I say, well, it arises in this case because the exercise of the powers in this case were prompted by and deliberately intended to thwart the choice of the accused in this case to have Mr. Barlow as leading counsel. So they were the disciplinary functions in which the Bar Council only have direct jurisdiction over their own members have been used in a manner which directly affects the interests and the convention rights of this individual and were so intended. So therefore, he is a victim of their actions and they have responsibility to respect his convention rights. So that's where it comes in. But as I say, it doesn't mean that there's some kind of empowerment because they're a public authority, that they have authority over the public, which is just species.
Yeah, I think so.
They talk about this being just about the designation of one's counsel, and there isn't a fundamental right to have a leading counsel designated as such. And that's an argument which found favour in the court below. Again, that is wrong because they are saying that all that is protected as a fundamental right is the identity, the name of the counsel, and they say, well, he got his counsel, he ran his trial. But it's not just who he is, or she is, but what role that counsel can play in the trial. In this case, it is clear that the counsel leading a case ultimately is responsible for making the fundamental decisions on how defence will be conducted. That's why they're leading counsel as opposed to being led. And that is the role which the accused clearly wished Mr. Barlow, whom he knew and who'd acted for him before, to carry out. You are the one that makes the decisions. You say who to call, how to cross-examine, what submissions to make. You have those decisions. That's what he wants. That's what he's seeking. And when that's put to the Bar Council, they say, at page 244, in a letter of 13th March 2014, so page 243, penultimate paragraph, they say, it's unfortunate Mr. Barlow didn't ensure compliance with the rules in accepting the senior brief in this case. As you're aware, Minister of Justice appointed counsel to the rank of Queen's Counsel. Only the most experienced and able counsel achieve this rank. Under the grant of legal certificate, your client is entitled to have the benefits of both. And then they go on, and this is the part. It would, of course, then be a matter for counsel as to which conducted the cross-examination of a particular witness, and as to the role of each in the course of the trial process. So they're saying, well, as long as you've got your senior on board, then they can work out between them. In fact, hint, hint, Mr. Barlow can actually do all the heavy lifting in this one. That seems to be the suggestion. That is responded to by solicitors at page 245, saying that they are inhibiting his ability to instruct counsel.
Well, your short point surely is that yes, that's so, but it would depend on the decision of the leader.
Yes, absolutely, and that said, if your letter, as it says, 13th of March, is suggested that Mr. Barlow work as a junior to senior counsel, then counsel decide between them who cross-examines. As creative a suggestion as that would be, it's contrary to Mr. Maguire's instructions and artificial. Senior counsel are appointed to be lead advocate and are paid as such by the Legal Services Commission.
Well, I mean, in very short compass, your point is that senior counsel is responsible for the conduct of the trial. He or she could decide to conduct it entirely him or herself, and Mr. Barlow would effectively be excluded from
Absolutely, but it could be that the senior counsel says, actually, you know, I'm a fraud silk, actually, as in I prosecute frauds.
Yeah.
Maybe you should do most of the work on this, but then that's a matter for senior counsel having decided on it, rather than for the choice of the and the confidence of the accused, who says, look, I know Mr. Barlow, I want him to do it, I'm instructing him to do it. And anyway, a QC taking a backseat role, is that consonant with the rank and dignity of senior counsel? I mean, you might have difficulties, I would have thought, with the Bar Council itself, if you counsel took a Bar Council Code, page 302, says in terms, if the barrister's engaged as senior counsel, then it's for them to decide who makes the closing address and the like. So it's ultimately for the lead counsel to decide on these matters. That is a matter which is protected also as a matter of convention rights. We see this from the case of Dvorsky. In any case, which is at page 1638 at paragraph 78, and it's volume 2, tab 55, paragraph 78. So
I'm afraid we don't have tabs.
yes,
What page is it?
Give me the tab and I should be able to find it.
it's page 1638 is what is the passage I'm trying to get, but it should be the same page as on the bottom of the hard copy. Lord.
Yep.
Yes.
Actually, I'm not sure.
Sorry, paragraph.
I think I've given the wrong number as well.
Just give me the tab number again, please, Mr. O'Neill.
55.
55.
The tab number is 55, and it's in volume 1647. Apologies, 1647.
Paragraph 78.
Paragraph 78.
Thank you.
It says there, Article 6.3 guarantees everyone charged with a criminal offence following minimum rights to defend himself through legal rights of his choosing, and generally recognised in international human rights standards as a mechanism for ensuring an effective defence of the accused. The court emphasises that the fairness of proceedings requires that an accused should be able to obtain the whole range of services specifically associated with legal assistance. So it's not just that you get the counsel of your choice, but he gets to be and act as the counsel of your choice, in this case, providing the full range of legal services. The footnote for that is the case of Dayanan, which is at tab 53, page 1589.
Yes.
And it says at paragraph 32 at page 1594, again, so this is the quotation quoted. Indeed, the fairness of proceedings requires that an accused be able to obtain the whole range of services specifically associated with legal assistance. In that regard, counsel has to be able to secure, without restriction, fundamental aspects of the person's defence, discussion of the case, organisation of the defence, collection of evidence favourable, preparation for questioning, support for the accused in distress, checking of the conditions of detention. Clearly, that's a summary of what counsel in Turkey might do. In our case, counsel would, of course, be, lead counsel would be deciding on matters such as cross-examination, choice of witnesses, whether to call the accused and the like, but their decisions, and that's the full range of legal services that would be expected here. And on the issue about, well, he can do all that so long as you amend the certificate, which is what the Northern Ireland Bar says, i.e. says, well, although the court has said that this was a two-counsel case, I've decided I'm more than capable enough of doing it myself, and therefore will tell the legal aid authorities accordingly. This issue about withdrawing from a two-counsel case was raised again in evidence before the Justice Committee of the Northern Ireland Assembly at page 502, with the Attorney General, John Larkin, is giving evidence. Page 502 at the bottom of the page. He's asked, has there ever been a case of junior counsel or senior counsel being honest and saying, hold on a minute, I'm not needed, I'm withdrawing from the case? Does that happen often? And the Attorney General says, I don't know is the only candid answer I can give. It strikes me that the difficulty for senior counsel in that position is that where a judicial officer has determined there should be two counsel, one would be slow to walk away. Again, these days, the practice of law often takes place in a highly protective, fearful climate. Therefore, one would be slow to see someone walk off the pitch where he or she may expose himself to complaint from someone who says, well, the magistrate thought I should have two counsel, yet you're walking away. But that's precisely what the Northern Ireland Bar say Mr. Mark Barlow should have done. This is good, you can't be lead counsel, you think you're good enough to do this, amend the certificate, do it by yourself, tell the magistrate they got it wrong in getting two counsel certified. Moving on, and I will be brief, if slightly over the hour, I promised.
Don't worry, no, don't worry.
Lunch awaits. The suggestion again seems to be made that there's only a breach, and it's sort of inchoate, but I'm picking it out from the respondent's case. There's only a breach of Article 6.3c if there's a breach of the fairness, overall fairness, under Article 6.1. And they say, well, look, after all, in the trial that followed, he was represented just by Mr. Barlow on his own, and he wasn't convicted of all the charges. Therefore, what are we complaining about? There isn't really a breach of the right to counsel because he got a fair trial in the end, I think is what's being said. Two responses to that. One, we have no idea whether it was a fair trial or not. The fact that you're not found guilty of all the charges, in fact, there was a hung jury on a number of the charges, we don't know. So we can't say, well, there was a fair trial, therefore no breach of Article 6.1. In any event, it is clear that a breach of Article 6.3c is separate from and specific and different from the question of whether fairness overall has been breached. The case law of the Court of Justice is absolutely clear on that, in that they rely on the case of Dvorsky that we've just looked at, where there was a finding that there was both breach of Article 6.3c, a choice of counsel, and fairness. Now, of course, that can happen, that the choice of counsel leads to unfairness, but the restriction on choice of counsel doesn't have to lead unfairness to be a breach of convention rights. Lord Clyde gets this right in McLean against Buchanan, which is page 1213. It's tab 37, page 1203. Sorry.
Which paragraph?
No, it's page 1222. Sorry about that. It's paragraph 62 of Lord Clyde's judgment. Lord Clyde's judgment in this case, McLean goes, it's one of the earlier ones dealing with convention rights, so he goes through at some length about what the convention on case law is on Article 6.3c. He says it's not necessary for contravention of Article 6.3c that the accused should have suffered injury as a result of the contravention as against Switzerland. He need not show that with an effective representative the trial would have gone differently or the outcome would have been different. Where in a serious case an accused has no effective representation, that fact may be enough to constitute a contravention. He refers to Article, that's i.e. a contravention of Article 6.1. But anyway, the basic position is, and we have the cases of Article and Pikeli if the court requires them because they weren't in the bundle, but they say in terms of findings of there's absolutely nothing in Article 6.3c indicating that you have to show prejudice by the lack of the restriction on the choice. That's a matter ultimately for damages perhaps, but it's not as to whether or not there's a breach because you come first to Article 6.3c and they say that at paragraph 35. As I say, I have copies, my Lord, which I can hand up simply.
Well, basically your point is that Article 6.3c is in essence a prospective right, a fact or a circumstance that one is not convicted doesn't necessarily mean that there hasn't been a breach of Article 636.
That's it, absolutely, so, my Lord. It says, in the following minimum rights shall be guaranteed to anyone charged with a criminal offence. Anyway, the case law is to that effect, and nothing in Dvorsky says otherwise. The point which I was now going to look at is the respondent as a public authority. In a sense, we've already dealt with that, touched on it. But it was the basis upon which the court below found in favour. It talks about this idea of the triangulation of interest between the accused, the victim, and his family, and that the Bar Council were properly quite correct in applying and interpreting Rule 20.11 in the way that they did. But the triangulation of interest, which is a phrase which is it seems to be one which is particularly resonant in the Northern Ireland case law when one does a search for this, is a phrase of Lord Staines about, in Attorney General's reference, where he says, in a criminal case, the court is required to consider a triangulation of interests. It involves taking into account the position of the accused, the victim, and his family. That passage is quoted in the judgments below at page 180 in Lord Chief Justice Morgan's opinion, and page 190 at Lord Justice Gillen's. But anyway, the point is, it's, of course, triangulation of interests, what I would call the balancing of interest between choice, public funding, and a fair trial, is a matter which these factors come into account, but it's the court which is to ensure that ultimately under our constitution. And it's not for the Northern Ireland Bar to come in and rejig that balance as they think appropriate, given their view of the high standards which are embodied once one manages to get silk in Northern Ireland, and abilities which are, if not conferred, then recognised. So that's that point. So I've said basically they're using these disciplinary functions and regulatory rules in a manner which effectively comes in and tries to rebalance things, and it's rebalancing things actually, it looks like, I'm sorry to say, in favour of the senior bar in Northern Ireland. Now, I've quoted cases about, in competition law and the case law, about how one has to be careful when dealing with regulations by a self-regulating profession, that the temptation is there sometimes to gold plate matters in the public interest and make things more restrictive than, in fact, the balance which the legislature has fixed. And quoted the case in particular of the Ordre National des Pharmaciens, ONP, which is at tab 66, page 876, and the passage in particular is at page 1920, paragraph 347, but it's already quoted in the case, and the court, general court there says, it's not for a body representing private persons to extend the scope of protection of the law with the desire of protecting the interests of a group when the legislature had defined the limits of protection offered and left the possibility open for a certain amount of competition. So it comes down to this issue, competition, and the fact that the Northern Ireland Bar are, when it comes down to it, a association of individuals who are in the marketplace providing legal services. I know marketplace and legal services is something which the court had urged caution on, at least in the Unison case. But in relation to those who might provide legal service, clearly there is a market place. At paragraph 157 of their case, paragraph 108 rather, at page 157, the respondent states that strikingly the appellant's contention ignores the fact that solicitor advocates may be appointed Queen's Counsel. When I suggested that perhaps this is not wholly just about the public interest, it may be retorted strikingly that there are no solicitor advocates who are Queen's Counsel in Northern Ireland. There only ever was one, Barra McGrory, as I understand it, who was awarded silk in 2007, then joined the Northern Ireland Bar in 2009, and then became DPP 2011. So no Northern Ireland solicitors with rights of audience in the Crown Court have been awarded silk. So when you do have a case importing a disciplinary rule that says only Queen's Counsel have to be instructed, that is, in reality, favouring the bar over solicitors. It's also said that I've made bold and unsubstantiated claims that the interests of the bar are what motivates them in this matter. I would just refer on that point to following passages briefly. Page 409, which is the evidence of Mr. Adrian Colton, QC of the Northern Ireland Bar, to the Justice Committee on the 17th of June 2010. It says, the suggestion that 2 junior counsels should be on a case is misconstrued and ill-advised. If 2 counsel are needed, one must be senior counsel and the other must be junior counsel. That is why there are senior counsel. What's the point of having 2 junior counsel in a case? There must either be 1 junior counsel if they can deal with the case fairly in the interest of justice, or if 2 counsel are necessary, there must be 1 senior counsel and 1 junior counsel. To do otherwise is to make a nonsense of the rank of senior counsel. So the focus does seem to be on the rank of senior counsel. There's no mention of client choice or the interest of justice, at least there. Page 447 to 8, a letter from Adrian Colton, QC of the Bar Council, again to the Northern Ireland Committee of Justice.
Sorry, what's that page reference again, please?
It's the letter begins at page 446, and the passages I was looking at are 447 to 448. On.
Yes. Yes.
Sorry. It says the significant radical overhaul of the interest of justice test will have a huge impact on the retention of Queen's Counsel in the vast majority of serious cases in Northern Ireland. Then at 447, the last paragraph, in Northern Ireland there are a total of 69 QCs. The change in criteria for the retention of Queen's Counsel in the Crown Court will have a huge impact on all Queen's Counsel within the Bar Library who currently work in serious cases in the Crown Court. We understand that at the last meeting the committee discussed the potential implication of the changes to 2 Counsel and Catholic Queen's Counsel and referred to submissions of the Committee on the Administration of Justice, the respected agency, independent of the bar. There's clearly a risk that the proposal on 2 Counsel will have a similar effect. The proposal suggested by the Court Service will have a marked and devastating impact in relation to the practice of each and every one of these Queen's Counsel whose practice primarily in the Crown Court. And they say that no equality assessment has been carried out on their part. So again, the focus is on the devastating impact on Queen's Counsel. The question is this, well, what's the point of having Queen's Counsel if they don't get to automatically be appointed in 2 Counsel cases? Page 484, a letter from, again, Adrian Colton to the Northern Ireland Minister of Justice.
484.
Yes, it's a letter of 9th of March 2011, beginning at page 483. So at the top of page 43, middle of the first paragraph after the italicised juniors, senior juniors, QCs, the concept of 2 junior counsel appearing offends against the very architecture of the profession. This is particularly so in circumstances where we hope to move to a new competition for silk. Put simply, if a case is sufficiently complex or serious to merit representation by 2 counsel, then that should mean a junior counsel and senior counsel. To do otherwise offends against the very concept of senior counsel in this jurisdiction. And then I would urge you to look again at this matter with a devolutionist eye. I'm unaware of any pressure or lobby to think in favour of such a clause, and I think it offends against the whole architecture of the profession. and the underlying reasons for granting a certificate to the Council. So, that certainly looks on the face of it to be evidence that the concern is the impact that the change would have on Queen's Counsel. No reference, the practice of Queen's Counsel as currently constituted, no reference to fundamental rights of choice, no reference to the interests of justice, but just that we do it differently in Northern Ireland. I say you can't do it differently in Northern Ireland if, in so doing, you are in breach of fundamental constitutional principles in relation to choice of counsel and as protected by the Convention. For those reasons, I submit that this appeal should succeed. And I would so move the court.
Very well done. Thank you, Mr. Reedy.
Sorry for being a bit rushed.
Not at all. Ms. Davies? Ms. Davies?
No, thank you.
Thank you. Mr. Schofield.
I'm very grateful, my Lord, my Lordships, my Lady. Lords, my Lady, as we've observed in paragraph 7 of our printed case, the appellant has only 2 points which are live in this appeal. Subject, I should say, to my learned friend's exchange with Lady Black, it might be that we're down to 1 point in the appeal, but as we understand the written case, there are 2 points that we need to address. Each of those points is directed to a claimed breach of Article 6(3)(c) of the Convention. The first point, although discussed in terms of constitutional competence, amounts to a claim that any restriction on Mr Maguire's choice of counsel is not in accordance with law for the purposes of the Convention. I should say, my Lords, my Lady, that's an entirely new point. It wasn't raised or argued in the court below. And it explains, I hope, if not excuses, the length that we've gone to in our written case to explain something about how the position of the bar in Northern Ireland is regulated and why that is. The second point is that the interference with Mr Maguire's Article 6 rights is not proportionate. And the court will have seen from our printed case that we say that there's a very short and simple answer to each of those grounds of appeal. On the first point, there is plainly, we submit, a sufficient basis in law for the Bar Council exercising power in this field. And that can be dealt with by reference to a number of short statutory provisions which weren't referred to in my learned friend's case and in fact haven't been addressed in his oral submissions this morning either. So I'll take the court to those in due course. And on the second point, we say simply that a proportionality analysis is inapt in this type of case. If the appellant's Article 6(3)(c) entitlement has been restricted, the case law of the Strasbourg Court makes clear that the standard of review is one of fairness, not proportionality, but fairness, and fairness taking the proceedings as a whole. And there was no... Very grateful. There was no unfairness in this case for the reasons that we've set out in writing and that I'll come on to. But my Lords, my Lady, there's a logically prior point of objection to the appellant's case, which is that his Article 6(3)(c) rights haven't been interfered with at all, since this is a case where the applicant could and did have the legal assistance of his choosing, that is to say, the services of Mr Barlow. Mr Barlow, as we've heard, appeared for the applicant, for the appellant on his retrial. That resulted in a hung jury again, and the Crown have indicated that they will not seek a further retrial. So there was no impediment at all to Mr Barlow being instructed. And we say that properly understood and analysed, this is a case simply about how Mr Barlow is or was designated. And so far as the statutory scheme upon which the appellant relies is concerned, that issue sounds only upon how much Mr Barlow is paid. But the issue of the precise designation of a lawyer acting on your team is not something we submit to which Article 6(3)(c) speaks. So I want to begin by addressing that point firstly, and then after that to move on to look hopefully economically at the two grounds of appeal which are raised in my learned friend's submissions.
When you say this is just a question of designation, but Mr O'Neill's point is surely that it's not simply a question of having Mr Barlow on your team. It's the role that he plays and the assistance that he can derive from having another counsel. So it's not an answer, Mr. O'Neill, I think, would say, simply to point out that Mr. Barlow could and indeed did represent Mr. Maguire on the second trial. He did so in circumstances where he did not have the assistance of a second counsel or a second solicitor advocate or whatever.
Well, my lord, he could have had the assistance of a second counsel. Indeed, he could have had the assistance of a senior counsel.
I'm wondering, is it a 6.3c point, or is it perhaps a 6.1 point? I mean, if you have the counsel if you're represented by the counsel you wanted to have represent you, that seems to be what 6.3c is directed at.
Quite so, my lord.
If he doesn't have the level of assistance provided by the Legal Aid Fund, which, in combination with the Code of Conduct of the Bar, that you would have wanted him to have, I wonder if that's really to do with choice of counsel, or if it may not perhaps be to do with whether the defence was adequately resourced, which is more of a fairness issue than a choice issue.
Lord, certainly the case has never been put that way. One of the points that we make is that Article 6.3c, and we'll see this in the case law, has to be read with Article 6.1. They're both about fairness. They both require an assessment of fairness. And other than this particular issue about Mr. Barlow not being the leading counsel, there's been no other question of fairness raised.
Yeah.
Well, when Ms. Bagnall gave a certificate for true counsel, she presumably considered that it was in the interest of justice and therefore in the interest of fairness that there be two counsel to represent Mr. Maguire.
I think that is so, my lord, but I could make a number of points about that. Firstly, your lordships and your ladyship will have seen that the divisional court was unhappy about the way in which the application had been advanced and the way in which the district judge had resolved the application.
Yes, but that's just this case, Mr. Schofield. Come on. The certificate was granted. The issue of principle is, if the certificate is granted, what flows?
Well, that's right. 2 points in relation to that, my lord. First, again, and I hope I don't weary the court by repeating this point on a number of occasions, but the appellant
won't
was...
be allowed to do weary.
Well, I'm quite sure that's the case, my lord. But the appellant was entitled to counsel. That's what the court said he should have. That's what he was permitted to have. And there was absolutely no restriction on him having Mr. Barlow and the assistance of another counsel, not merely the assistance of a junior counsel, but the assistance of a senior counsel of his choosing. But the second point is this: the mere fact that a district judge, at a very early stage of the proceedings, takes the view, on the basis of grounds that are advanced to him or her, that it's a case which is appropriate for two counsel, does not mean that if the appellant ends up with one counsel, the case has, per se, been conducted with unfairness to him. The two don't follow. By necessity, the district judge has to take a view at a very early stage, and if, for some reason, in this case, of course, it was by his own choice, but if for some reason the defendant ends up with only one counsel, one cannot say, per se, there must be, of necessity, an Article 6 breach. If I can just take your lordships and your ladyship through some brief submissions on what Article 6.3c covers and what it doesn't.
Do we have Article 6 somewhere?
We do, my lord.
There is a provision in 6.3 about the adequacy of the resources, I think.
Tab 16.
Which tab?
Tab 16.
Not 16,
That's the ICCPR.
Try 15.
15, Article
Well,
685 in my bundle, my lords, my lady.
685, yes.
685.
oh, I see. Yeah,
684, I think. 684.
As I said, my Lords, my Lady, this is a case which has been squarely argued at all times on the basis of Article 6.3c.
Article 6.3c says that he's entitled to defend himself in person or through legal assistance of his own choosing. So the defending himself governs the legal assistance of his own choosing, doesn't it? And the argument surely is, on behalf of the appellant, that he needs to defend himself through legal assistance of his own choosing, namely Mr. Barlow, assisted by another advocate, shall we put it that way?
Yes, my Lord, and again, at the risk of repetition, he's perfectly entitled to have Mr. Barlow, and he's perfectly entitled to have Mr. Barlow with the assistance of another advocate. The issue here is the designation of that other advocate.
No, it's not only the designation, it's the choice of the other advocate, isn't it?
You can't refer to junior counsel who is led as having the assistance of his leader, can you?
I don't see any reason why not, my Lord. I wouldn't for a
Well,
moment
because
suggest...
the reason why not is because surely the leader is in control of the exercise, makes the decisions.
I'll come on to that point if I can in just a moment, my Lord. But in our submission, certainly the way in which I understand the role of senior counsel and the way in which I think it operates in Northern Ireland, the counsel team, indeed all of the legal team, operate as a team. There is discussion and debate about who should take which aspect of the case. There's a division of labour which is discussed with the solicitor, with the client, and which is agreed upon.
Well, yes, there is, but who has the final say?
Well, Lord, perhaps I can take your Lordship to the Bar Code of Conduct on that, because what the code says is actually extremely limited on that issue. My learned friend, I think, referred in passing to the one provision of the code which speaks to it. But the limited reference doesn't give one a full picture. So perhaps the court would take up the core bundle, or the core volume, and the Code of Conduct commences at page 281, and the relevant provision is at page 302. And paragraph 9.23 of the code, to which my learned friend referred in passing, is really the only provision of the code which speaks to this issue. It is extremely non-prescriptive. My learned friend, I think, sought to give the impression that the senior counsel would lead the team in somewhat of a dictatorial fashion. But the court will see, in a case in which more than one barrister is engaged, it is for the senior counsel, or where appropriate, the leading junior counsel, to decide which of the barristers will make the closing address. But whoever it is, it has to be someone who has been present during a substantial part of the case. 2 points about that.
I suppose that makes some sense.
It does. Not always so, my Lord.
Well, I know.
But firstly, there's a decision to be made, but there's a discretion. There is no hard and fast rule. And as I've said, that's a decision that will be made by discussion amongst the team. But secondly, this is the only indication which is given in the code as to the respective division of roles. There's nothing whatsoever prescriptive about there being a joint team decision.
But in the absence of prescription, as my Lord Hughes has said, surely any strategic or tactical decision that are to be taken, senior counsel will have the final say. For instance, he will or she will have the final say as to which witnesses will be taken. I mean, that's common experience, is it not?
That would be the general expectation, my Lord. Subject, of course, to the views of the client. There are certain issues where the client's instructions will hold sway. For instance, I think the code says it is for the defendant to decide himself whether he or she wishes to give evidence, and that's not a call for any of the counsel team.
Oh, quite.
Well, no, again, that forgive me, that's because of the evidential provisions.
Yeah.
The significance which is attached to not doing so, surely.
That might well be the case, my Lord.
Yeah. He has to be personally warned, doesn't he?
He does, my Lord, yes.
Right.
If I can go back just to the very basic point I've made, which the court now has, Mr. Barlow was entitled to be instructed. In fact, the appellant here had a range of choices. He was entitled to have Mr. Barlow and a senior counsel, and the respondent considers that that is the best guarantee of fairness in such cases. Or he could have Mr. Barlow as a leading junior counsel if there was no competent senior counsel practising in the area available. And I do make the small point on the facts that there seems to have been very little investigation undertaken about that avenue, or, as indeed occurred in this case on the retrial, the appellant was entitled to have Mr. Barlow acting as his sole counsel, assisted by his solicitor.
Well, just as a matter of mechanics, how did that come about? Was the certificate amended, or?
The short answer to that, my lord, is we don't know. We did, in advance of this hearing, write and inquire what had happened at the retrial, and we've been told that that is what happened, but not, to use your lordship's phrase, the mechanics of how it happened.
Well, would you need to amend the certificate? I mean, it's permissive, the certificate, isn't it, in this sense? You're not obliged to apply for one in the first place.
Yes, my lord.
I suppose you're not obliged to.
And you're not necessarily obliged to take advantage of it if you have applied for it, are you?
No, that's quite right, my lord.
Yeah.
Right.
That was an option which was open and which was taken. But going back to the cases, my learned friend has been able to point to no Strasbourg authority which says that a defendant is entitled to insist upon a lawyer of his choice who's providing him with assistance having a particular status or designation within the team. And in our submission, for this court to so hold would go well beyond where the Strasbourg jurisprudence on Article 6.3c has reached. In fact, my lords, my lady, in our submission, there are several Strasbourg cases which point in the opposite direction, that Article 6.3 embraces no such right. Before turning to those cases, I ask the court just to note 4 basic points. Firstly, the text of Article 6.3 uses only the phrase legal assistance. It goes no further than that. Secondly, the notion of lead advocate, as the appellant uses that term, may well be one which is not well known in civil law jurisdictions across Europe which apply the Convention, with the exception of Scotland, I say before my Lord Reid corrects me. Thirdly, this case, as the court will have seen in looking at the authorities, is very far from the standard Article 6.3 cases which come before the Strasbourg court. They tend to fall into one of 2 categories. Either they involve a specific lawyer being forced onto the defendant's representation team without his choice and against his wishes. That's the Croissant and Germany case and the Correia de Matos versus Portugal case. Or there are instances where an identified lawyer who the defendant wants to assist him has been completely excluded from the team. So that's cases such as Dvorsky versus Croatia, Klementiev versus Russia, and Martin versus Estonia. This case, we say, is very far removed from the usual complaints made under Article 6. And the 4th introductory point is this. The case law is clear and consistent that Article 6 does not guarantee an absolute right to counsel of one's choice. And that being so, we submit that it is even less likely to guarantee an absolute right to the particular designated role of the counsel of one's choice. And before finishing this point, I want to take the court just briefly to 2 of the cases, one to identify a principle and the other to show a practical example. So firstly, if the court would turn to the Correia de Matos case, and that is in the Authorities Volume 2, and it commences at page 1509.
Are you going to cover at any point the interpretation of the regulations?
Sorry, my lord?
Are you going to at any point cover the interpretation of Regulation 4?
Yes, my lord. I'll come on to that.
Yes.
The reason I'm addressing this point first, my Lord, is because if we're right in this, and that this particular type of choice is not within the ambit of Article 6, then the rest of my learned friend's case falls away in our submission. I was taking the court to page 1509. That's the Correa de Matos case. This was a case where the applicant was a lawyer. It's remarkable how many of the accused in these cases are lawyers. It was one of the features which jumped out at me. But he was a lawyer. He wanted to represent himself, and he wasn't permitted to. And the court imposed a lawyer upon him who he didn't want. And if the court would turn to page 1513, there's a couple of points here, my Lords, my Lady, which emerge from a number of the cases. I'm not going to take the court to all of them, but I'll perhaps just point some of them out as we go through. But halfway down the page, on page 1513, the court will say, the court will examine the applicant's complaint in accordance with the general rule set out in paragraph 1 of Article 6, while bearing in mind the requirements of paragraph 3c. This is an entirely standard approach. In these cases, Article 6.3c is viewed as one particular instance of, or is taken together with, a general fairness complaint under Article 6.1. Next paragraph, the court observes that the Commission ruled on a number of occasions on the right to defend oneself in person provided for in Article 6.
Sorry, I haven't found this passage. Where is it, please?
Sorry, my Lord, page 1513.
Yes.
Halfway down the page is the paragraph I've just taken the court to. And we're now looking at the penultimate paragraph.
What does the paragraph begin, please, Mr. Scott?
It observes that the Commission ruled.
Yeah, I think it must be a different.
Your page is
It's 1512, actually.
Yeah.
1512.
1512. Yes, quite.
The hard copies are one page different in numbering from the electronic copies.
Very good, my Lord.
So the court will examine the applicant's complaint in accordance with the general rule. Yes, I've got that now.
So, the court looks at fairness. That's the first point. Next paragraph, the Commission has already ruled in a number of these cases. In the X versus Norway case, the Commission held that although this provision guarantees the proceedings against the accused will not take place without adequate representation for the defence, this is the statement of principle, it does not give the accused the right to decide himself in what manner his defence should be assured. Now, that's a statement of principle which is repeated in a number of the cases. I'll just give the court two references. The court will see the same thing in K versus Denmark. That's at page 1736. And also in Mazet versus Russia, 1796. And that's paragraph 65.
So the second reference again,
1796.
6.
I hope that's right, my Lord. I'm now subtracting 1 from each of the numbers I've made in my notes.
Which paragraph is
It's paragraph 65, my Lord.
65?
So, statement of principle, if I can perhaps gloss that somewhat, the accused does not get to dictate everything on his terms. It depends on the applicable legislation, the rules of court, and then we see there's reference to the Weber decision, and it's the issue is one for the competent authorities. Now, my learned friend says, oh, it has to be the court. In many cases, it is the court who's making these decisions, but that is not exhaustive of who the competent authorities may be. In the Dvorsky case, we see the phrase national authorities. Often it will be the court, but it need not necessarily be so. Then over the page, page 1513, the second paragraph, the court does not see any reason to depart from that case law. It considers that in this area, it is essential for applicants to be in a position to present their defence appropriately. That is what all of the Article 6.3 guarantees are aimed at. And then they have to be able to present their defence appropriately in accordance with the requirements of a fair trial. The decision to allow an accused to defend himself or herself in person or to assign him a lawyer still falls within the margin of appreciation. The contracting states are better placed than the court to choose the appropriate means by which to enable the judicial system to guarantee the rights of the defence. It should be stressed that the reasons relied on for requiring compulsory representation by a lawyer for certain stages of the proceedings are, in the court's view, sufficient and relevant. It is, in particular, a measure in the interests of the accused designed to ensure the proper defence of his interests.
So that's a decision, is it, that a national rule which requires legal representation rather than self-representation is within Article 6.
Quite so, my Lord. And we would say, and there are some other cases which perhaps speak to this more directly, a national rule which requires representation of a particular type or a particular level or a particular competence or expertise is similarly within the terms of Article 6. Just at the very bottom of that page, I asked the court to note again that the ultimate question for the court was whether the trial was unfair. But the key principle that I wanted to take the court to there was, as we've seen on the preceding page, Article 6 does not give the accused the right to decide himself in what manner his defence should be assured. So that was the principle. One particular example of that principle in practice we submit, which is perhaps the case which is closest to the present case on the facts, is a case called Zankovic versus Germany. And the court will find that commencing at page 1673. If you're using the hard copy bundle, that should be in the same bundle.
1673.
73. This is a 2009 case of the court. It's dealt with in our printed case at paragraphs 95 and 96. The reason why we say this case is perhaps of particular assistance to the court is because it was a case where the applicant had the lawyer he wanted, but not with the particular designation that he sought. So the facts are set out on page 1674. We see from the middle section of that page that in August 2008, Mr. B, the applicant's lawyer, appointed himself counsel chosen by the applicant. The next paragraph, in September 2008, he lodged a request to be appointed as the applicant's official defence counsel. The Cologne Public Prosecutor's Office declined to make that request, and in due course, Mr. B was not, therefore, designated as the official defence counsel, but he was still providing assistance to the applicant. And if the court then turns to page 1677, at the top of that page, we see that the court notes that the case raises issues under Article 6.3c, laying down specific rights. The guarantees in paragraph 3 of Article 6 are specific aspects of the right to a fair trial set out in paragraph 1. It will therefore examine the complaints under both provisions taken together, again, looking simply at the issue of fairness. Then on the next page, 1678, second paragraph, really the same point. As regards the right of a person charged with a criminal offence to free legal assistance, the court observes that this right is one element, amongst others, of the concept of a fair trial. And then next paragraph, just in the middle of that page. Turning to the facts of the instant case, the court notes that the refusal to appoint Mr. B, the applicant's chosen defence counsel, as official defence counsel, did not disclose a lack of respect for his defence rights. Even assuming the applicant eventually lacked the financial means to pay for a defence counsel of his own choosing, the court notes that he had indeed, as soon as the request for his questioning was launched, access to a lawyer. Since August 2008, he had been represented by counsel of his own choosing, and the counsel performed different procedural acts for him. Then there's reference to what some of those acts were. And then at the bottom of that paragraph, hence the interests of justice did not require that the applicant's chosen defence counsel be appointed official defence counsel. The applicant has been, and still is, represented by the same counsel of his own choosing, and he's not put forward any grounds making a different procedural approach necessary to ensure the rights of the defence in this case. Against this background, the court finds that there's no indication of a violation of Article 6.1 and 3c. It follows that the application is manifestly ill-founded. So in that case, where the applicant had the assistance of the lawyer he wanted, just not with the particular title that he wanted, the court said, in effect, he wasn't even within the ballpark of an Article 6.3c breach. As he had the lawyer that he wanted, no claim arose. And on that basis, we submit that the court, in fact, in this case, doesn't need to concern itself with questions of legality or justification. There simply is no arguable breach. The applicant had and was always entitled to the assistance that he sought.
Does the report tell us somewhere, Mr. Schofield, what the significance was of either being appointed official defence counsel, or in this case not been?
I have to say, my Lord, that's not entirely clear. I think ultimately it resolves to who was likely to pay for the counsel. And of course, your Lordship, your Ladyship have the point that in this case, the principal significance of how Mr Barlow was designated under the 2005 rules is really how much he is paid. That's all the 2005 rules are dealing with.
Yeah.
So, your Lordship, your Ladyship have the point. This is not the type of choice which Article 6.3c is concerned with at all. If we're right on that, the court can dispense with this appeal extremely quickly. So any submission I make hereafter is without prejudice to that objection in limine to the appellant's case. Before I move on to the other two grounds of appeal, I wonder if I can just make some very brief observations about the facts in this case. One of the things which appears from the Dvorsky case is that if the court gets to the stage of looking at the justification for any restriction, then it has to look at the full context and look at all of the facts as a whole. So there's a number of points to make about that which may be of assistance to the court. The first point is this. We say that the appellant was always entitled to instruct Mr Barlow. At least at one point, there seems to have been some confusion on the appellant's part about that. And we see that from the handwritten letter that he submitted, which the court finds in my court volume, page 233, so it may be in the court's papers at 232. Some of this is not terribly easy to decipher, but I'm looking at a passage which begins 8 lines down. So Mr Maguire wrote, Mr Mark Barlow, who has been my lead counsel from day one of this case, informed me that he is no longer able to be my lead counsel and my advocate in my case, and I have to get a QC. And then just towards the bottom of that page, 6 lines up, I don't understand how Mark Barlow BL cannot continue to represent me, as there was not a problem during the trial last year. And it seemed to us, from a reading of that letter, that there was confusion on the part of the effect of the rule which is impugned in these proceedings. Mr Maguire seemed to think that Mr Barlow couldn't be his advocate and couldn't continue to represent him. Both of those propositions are, of course, simply wrong. And it's curious how Mr Maguire felt that that was the case, having received advice about the matter. The second point on the facts is that the main, and in fact the only proffered reason why Mr Maguire wanted Mr Barlow to act was because he had appeared for him in the first trial and therefore was familiar with his case. And the strong likelihood we submit is that that situation came about because of a prior breach of the code of conduct on the part of Mr Barlow. That's, it seems, how the situation came to be. The third point is that there is a complete dearth of evidence as to precisely what Mr Maguire was advised at the very initial stages when he decided that he didn't want to have a senior counsel before the first trial. So we don't know what he was advised about his options. We don't know what he was advised about the availability of senior counsel, or if any inquiries were made about that. We don't know what he was told about the significance of the rank of senior counsel. And all of those matters, the court will have seen, are issues which the Addison case says have to be discussed in great detail with a client before they can make a properly informed choice. What might be likely to have occurred at that stage can perhaps be gleaned from what Mr Barlow told the summary panel of the Professional Conduct Committee in September 2013 about what his practice was, and the court will see that at page 361. Just at the bottom of that page, Mr Barlow describes the practice that he had in dealing with these matters. He says, "It had been my practice in all the time that I've been in this jurisdiction that if there's a certificate for two counsel, either myself or my instructing solicitors will explain that to the client and to explain what it means that they have the entitlement to have leading QC or senior counsel to represent them with a junior, and it is entirely a matter for themselves. If they make it quite clear to me that they want a leading counsel, senior counsel, then one is sought. If I take the view, and there has been cases where I've been involved where I have taken the view that a senior counsel is required, I tell that to my instructing solicitors." So we say, with great respect to Mr Barlow, that if that is what happened in this case, that does not discharge the heavy obligation set out in the Addison case to give clear advice about all of the matters which have to be addressed with the client, including the significance of the rank of senior counsel, to give advice and then to let the client make an informed choice. As the court in the Addison case said, the Lord Justice General Gill, a mere recital of the options is no more than a formality if it's not supplemented by advice. But the fourth and last point, just on the facts, is we say that there is an extremely significant averment tucked away in paragraph 35 of the appellant's grounding affidavit. The court will find that at page 201 of the core bundle. And at the top of that page, paragraph 35 of the appellant's evidence, he says, "I do understand that in most cases where defendants are issued with a certificate for two counsel, the usual practice will be to instruct a QC as well as a junior counsel." And then this phrase, "If the circumstances were different in my case, then I do believe I may have taken that same course of action." Now, the circumstances being different is not clearly explained. It's not unpacked. The applicant doesn't elaborate on what that means. But it does seem likely in our submission that if he had been given the very full advice at the start that he ought to have been, he may well have chosen to instruct a QC, or indeed that if Mr Barlow hadn't led at his first trial, then he would have instructed a senior and junior counsel in the usual way. So those are just the short points I wanted to make on the facts before moving on to my learned friend's first ground of appeal. So the first ground of appeal is that any restriction in this case is not prescribed by law. The first point that we make about that, my lords, my lady, is that we don't accept that that is an applicable test in this case. As we've said in our printed case, case law makes clear that Article 6 is a right which is subject to certain limitations. And if the claimed violation is simply a manifestation of a limitation which is inherent in the right, then there is no need for justification at all. The right simply hasn't been restricted in a material way. And one of the things that we say is quite striking about all of these cases is, subject to correction, it doesn't seem that any of them ask as a separate question whether any restriction is prescribed by law. But let's assume against me that we need to show that the restriction here is prescribed by law. The next point that we make is that that requirement, that threshold, is a low one. So if we leave aside for a moment the issues of foreseeability and accessibility, and no issue has been raised with either of those in this case, the requirement that a restriction of a convention right be in accordance with law is a modest threshold. It must have some basis in domestic law, and we take that phrase from the Barthold versus Germany case, paragraph 45, that's at page 1531, from the Dogru versus France case, paragraph 49, page 1613, and also paragraph 79 of the opinion of Lady Hale, Lord Hodge and Lord Reid in the Christian Institute case. That's page 1081. So there has to be some basis in domestic law. The Dogru case makes clear that that includes law in its substantive sense, not its formal one. So the rules of a professional body on their own can be law for this purpose. And for that proposition, we say, see the portion of Blackstone's Guide to the Human Rights Act, which we've referred to at paragraph 75 of our case, the Barthold versus Germany case about vets' professional rules, and the Casado-Coca case about the Barcelona Bar Council rules. But in fact, my Lords, my Lady, there is a much more obvious and direct statutory basis for the Bar Council's power to act in this area, which we've set out in some detail in paragraphs 47 to 59 of our printed case. The Court finds that at pages 129 to 134 of the core volume. I want to take the Court to these statutory provisions briefly. The reason I do that is because they weren't raised below. This point wasn't an issue below, and therefore the Court doesn't have the benefit of the Divisional Court's discussion. And as I've said, they haven't been dealt with in my learned friend's printed case, and they haven't indeed been dealt with in his oral submissions this morning either. But the backdrop to this is the claim that we are trying to meet is the claim in paragraph 5.6 of the appellant's printed case, that the Bar Council cannot have been endowed with the power to purport to curtail or limit or otherwise impede the free choice of an individual accused as to who among those with rights of audience before that court that individual will instruct to conduct his defence. Nothing to do with the Bar Council. That's the case that we have to meet. But in our submission, that is precisely the power with which the Bar Council is endowed by statute in both the 1981 order and the 2003 order.
Can I just interrupt for a moment? Because on one view of it, there might be a much more direct route to this, that if the regulation was interpreted as requiring both types of counsel, junior and senior, then that would be the end of it, wouldn't it?
It would, my lady. Well, perhaps we'll look at that first. And I know this is an issue my Lord Reid was keen to come to.
You wouldn't need to go on to the Bar Council. Indeed, the Bar Council would then have the problem that they were being more permissive than the regulation.
Quite so. The rule would be over-generous
Yes.
in providing for the exceptional case. Well, maybe we'll just look at the text then of Rule 4. That's in Parties Volume 1. My copy, page 522. The Court's copy, probably 521. Rule 4.1, when granting a criminal aid certificate, the certifying authority shall, after taking account of representations, assign a solicitor. One of the points made in the court below, particularly by Lord Justice Gillen at paragraph 17, is that where the applicant or the defendant wants a solicitor advocate, they are appearing as a solicitor, exercising rights of audience under Section 50 of the Judicial Act, and they have to be assigned, the court assigns solicitors, including solicitor advocates. So here, if the applicant always wanted junior counsel and a solicitor, that should have been explained to the district judge. He should have said, what I want is a certificate which permits me to have a junior counsel, an instructing solicitor, and a solicitor advocate, the latter two being assigned. And as I've said, the court below was at least implicitly critical that that hadn't been addressed in the level of detail which might be expected, although in fairness to the district judge, she would not have had, I think, the detailed analysis of these provisions which the divisional court's judgment provided. So any solicitor, including a solicitor advocate, should be assigned. Rule 4.3 then is dealing with counsel being assigned, and we know from Rule 4...
counsel being instructed. Rule 3 is a rule that enables, it allows the solicitor who's been assigned under paragraph 1 to instruct counsel.
Quite so. So
there's no provision, for example, enabling the solicitor to instruct a solicitor in another firm who may be specialising in advocacy work.
Quite so, my lord. That's our point, that if the team is to have that structure, the instructing solicitor and the solicitor advocate should both be assigned. There's no provision for a solicitor advocate simply
solicitor advocate doesn't appear at all in the regulations, does it?
No, my lord, in these rules, there is simply a solicitor or a counsel, and a solicitor advocate, as we've come to know them, is legally speaking, for the purposes of these rules, simply a solicitor exercising rights of audience.
Well, I wonder, Mr. Clifford, you may be right, but and it may not matter, because it doesn't seem to me this case is about solicitor advocates, really. But what Rule 4.1 requires, yes, I think requires, is that when you grant a legal aid certificate, the court which grants it shall assign a solicitor. It's not one or more solicitors. And certainly the point was made in the divisional court that it's personal rather than the firm.
Yes, it should be a named person on the roll, was the view that the divisional court took. But
So where do you get from this regulation, at any rate, or do you get it from somewhere else? The proposition that where a solicitor advocate is going to conduct the case in one capacity or another, he has to be assigned.
we take it from this rule, my lord, as did the divisional court. Rule 4.1 is the only route into the legal team for a solicitor for whom legal aid provision is made.
Don't take us to them, but can you just at some stage give us a little list of the places in the legislation where the solicitor advocate appears?
It may not appear anywhere.
Yeah.
Not in this legislation.
Not in this act, not in these regs, no.
In the cost rules.
Yes.
I think that we'll have to check that. It might simply be a solicitor exercising certain powers or certain rights of audience, but I have a feeling that in the costs regs that there may be a reference to the phrase solicitor advocate, but we'll certainly check that, my lord.
Are they called High Courts advocates in Northern Ireland or not? They're not.
No. In Scotland, there's a dictum in one of the criminal appeals to the effect that there's no such thing as a solicitor advocate. There are solicitors who have rights of audience.
I think it's perhaps either Woodside or Addison. I think it's perhaps one of the cases in the bundle. But certainly there is a statement from one of the senior Scottish judges who says, as far as the court is concerned, counsel means counsel, and probably that a solicitor means solicitor. But
Yes, because you see, if the assignation of a solicitor were regarded simply as a solicitor to be responsible for the preparation and conduct of the defence, and who has the power to instruct counsel under 3, then the power to instruct counsel is only a power to instruct members of the bar.
yes, my lord.
In which case 4, 5, 6 and 7 have to be read the same way.
Yes, my lord, certainly if
And the certificate itself, which we have on, well, I have it on 526. I think those looking at computers have it on 525. It actually shows us the certificate. And it's, and sees a distinction drawn.
Of course, if one interprets it in that way, it would never be open to a solicitor to instruct a solicitor advocate, would it?
No.
Your Lordship is entirely correct, which is why I think we would take the view that it's likely that 4.1 is not limited in the way that my Lord Reid is positing.
Well, I think the difficulty in practical terms with your interpretation of Rule 4.1 is that one wouldn't always have chosen the representation at the time that the certificate is issued. And let us say that Mr. Neville was the assigned solicitor. I know he was the solicitor advocate, but let's say Mr. Davidson in Trevor Smith and Company was the assigned solicitor. He might not have chosen his counsel team at the time that he got the certificate. He might have done, but he might not.
He might well not have done, my Lord. And what the authority suggests he should do is he should sit his client down and in great detail explain who is available and the significance of the various qualifications and entitlements. But at that stage, if the client takes...
In any event, you say that if a solicitor advocate is going to be engaged, he or she has to be assigned under 4.1.
Quite so, my Lord, and that's what the divisional court held. It's the only route, as I've said, my Lord, for a solicitor to come into the legally aided provision of legal assistance in a criminal case. And in the case that your lordship suggests, if the client decides, I want a solicitor advocate, I don't want two counsel, I want a solicitor advocate, perhaps acting with a senior counsel, they go back to the magistrate and they say, this is who I want, please assign them. That is slightly off the point of the present case, of course. What we're dealing with is 4.3, but it's correct that for counsel, they can simply be instructed by a solicitor, and by virtue of Rule 4.4, they are deemed to have been assigned by the court. And on that issue that we've been discussing, there's no equivalent deeming provision for a solicitor advocate.
Yes. What's the significance of 4.4, which enables a member of the bar instructed under paragraph 3 to be regarded as having been assigned in pursuance of a certificate under Article 29 of the order? What does that enable them to get paid?
In brief, yes, my lord. Article 29 envisages that solicitor and counsel will be assigned, and what
and so there's no equivalent. There's no equivalent to 4 for the solicitor for a solicitor advocate.
No. What 4.4 does, my lord, is it means in essence that the magistrate or the district judge need not trouble themselves with who the particular counsel is. It's left to the solicitor to brief who they want, and they are deemed as having been assigned.
But really, the only way the solicitor enters the picture at all is through one.
Quite so, my lord.
Which I suppose is why Lord Justice Gillen was perhaps driven to the conclusion that he was.
Yes, my lord.
Because otherwise, I would have to say that the system being operated in practice is different from the system laid down in the legislation.
Yes, my lord.
Well, it follows that Mr. Neville ought never have took big pet. I don't know whether he was or not.
One imagines he was, my lord, and certainly for our part, we've no desire to try and deprive him.
No,
of
of course not. But I mean, on your interpretation of the provisions, he ought not to have been.
But depending on what my learned friend says in his reply.
But he ought not to have been, because he was never assigned.
Yes, my lord.
Yeah.
And of course, if Lord Justice Gillen is right, as we say he is, the scheme can work perfectly properly, but it just means that the district judge has to be told, either when the certificate is granted or at a later stage, precisely what it is that is proposed. And that we say that there's no rational objection to that, because...
Well, the prosaic truth may be, of course, that the solicitor advocates didn't enter the consciousness of the draftsman of these rules.
Yeah. In 2012, my lord, undoubtedly they would have done.
But are most of the terms of these rules copies of the preceding ones?
Yes.
They are, aren't they?
And I think they were from 1965 or thereabouts, my lord. Lords, can I come on to Regulation 4.3, which deals with the certificate for counsel. Any member of the bar who's practising in Northern Ireland and is willing to appear as counsel for legally aided persons in criminal cases may be instructed. So there is a choice on behalf of the assisted person by the solicitor assigned under paragraph 1. And then the rule seems to move on to deal with the separate situation where a certificate for two counsel is granted under paragraph 5b. In any case in which the certifying authority has granted a certificate is provided for under paragraph 5b, one such member of the bar and a member of the bar being one of Her Majesty's counsel who is practising in Northern Ireland or a senior counsel practising outside of Northern Ireland may be so instructed. And this is not a point which we argued below, and I'll accept that entirely because I know that's a point which is likely to be made against me in my learned friend's reply. But at the very least, the rule suggests that in a two-counsel case, where a certificate has been granted for two counsel, the expectation will be that that will be a member of the junior bar and a member of the senior bar. It is a perfectly proper interpretation of the rule that in that case, although it uses the permissive may in context, what the rule is saying is that where there is a certificate for two counsel, the people who should be briefed are a member of the junior bar and a member of the senior bar, either practising in Northern Ireland or outside Northern Ireland.
Well, there's a difference between those two formulations. One, that he should be a member of the senior bar, and the other, that the expectation is that he'll be a member of the senior bar.
Yes, my Lord.
Well, which of those do you espouse?
We espouse the latter as our primary submission, and the former as our fallback submission. But that,
Well, what's the significance of it being the expectation? If it's merely the expectation, then the possibility of briefing to junior counsel, particularly taken against the background exchanges between Mr. Coulton and Mr. Ford, it would not be imperative, would it, that senior counsel be instructed?
Well, if the court is minded to accept that the exchanges between the Bar Council and the Justice Committee or between the Department of Justice is relevant to the interpretation of the rules, there are a number of points that we'd want to make about that, because
well, we don't know whether we're minded to do that at all or not, but I mean, certainly, without getting too deeply enmeshed in the exchanges that took place, it appears that the expectation was that it would be possible to brief to junior counsel.
Well, there was a debate about that, and again, all of that is in the context of the costs rules, and the proposition initially was that there should be provision made for cases where two junior counsel are briefed. That was what the Department of Justice thought they would run with to begin with. The Bar Council said, no, that's a bad idea. The Bar Council and indeed the Attorney General said, that's a bad idea. That's not the practice here. It's not in the interest of justice. If there's a two-counsel case, it should be senior and junior, and that's what the regulations should say. Now, what the Department of Justice did ultimately, in the finest traditions of Northern Ireland politics, is that they just fudged that issue. They didn't say two junior counsel, they didn't say a junior and a senior, they just said two counsel and left the phrase constructively ambiguous. But the suggestion on the part of my learned friend that in some way the Department of Justice was here a champion of choice and wanted to increase choice for applicants, we say, is not a full or fair reading of the context. In fact, some of the materials that I can take the court to show very clearly that the department's concern was, perhaps unsurprisingly, limiting cost. They were not acting here as champions of choice. But the phrase which was selected to counsel was in the cost regulations was a neutral phrase.
The exchange to which the two documents to which Mr. O'Neill took us, briefing for the committee and letter to the chairman of the Bar Council, were those in the context of the regulations that we're now looking at, Regulation 4? Or did I hear you say that they were in the context of some other costs regulations? Or both?
Well, I think I'd like to check that, my Lord, in case I've inadvertently misled the court. The costs regulations, the amendment regulations were 2011.
Yes.
These regulations were 2012. There are a range of exchanges leading up to both of those, so perhaps we might need to look more carefully at what was said in relation to which set of regulations.
Yes.
But the Bar Council's position was consistent throughout. And indeed, one of the complaints it made in its correspondence was that the Department of Justice had at one point misrepresented its position. The Bar Council's position has always been that the interests of justice are best served in a complex case by senior and junior counsel.
And I suppose the rules would be made in a context, part of which was the existence of the Bar Council's rules, whatever they were at the relevant time. And it strikes me that if the certificate is to be granted and can only be granted in cases either of murder or where the case presents exceptional difficulties, it can hardly be the intention that you could, for example, instruct two counsel called the previous week. And there must be some intention that the counsel should have the qualities required to defend a person in that category of case. And
yes,
I suppose the department making the regulations could leave it to the Bar Council to regulate what sort of counsel can then appear.
Quite so, my Lord. That's a point I'll come on to later if we get to the stage of justification and what the public interest is in this rule, but I can encapsulate our submissions on that very simply. When one looks at the conditions for the grant of a two-counsel certificate in Rule 6 and Rule 7, it has to be a case either where the charge is murder, carrying a mandatory life sentence, or where the case presents exceptional difficulties. And that's defined not merely as a case involving a lot of spade work, but a case where there are substantial, novel or complex issues. And in our submission, an exceptional case requires and deserves an exceptional counsel. And the only kite mark that we have for that exceptionality is the rank of silk. So there would be nothing at all inconsistent in our submission with adopting a construction to Rule 4.3, which is that where exceptionality has been established, the requirement is to brief a member of the senior bar. I entirely accept if that is a proper construction, then as my Lady Black put to me, the Bar Council's rules are in fact overly generous.
Does Code 20.11 predate the 2012 regulations or not?
Yes, one of the points that we make is that this rule, and I'll come on to this when we look at the 2003
I'm sorry
order.
if I'm anticipating.
I'm sorry, my Lord, but this rule, in one form or another, has been in place since 1979.
Now, if you go on in the, so I'm afraid I'm electronic today, 524, you'll get to the revocation provision in these regulations, Regulation 8. Now, it's dangerous to guess. Should one deduce from that the previous equivalent certificates regulations were two lots of 1966 rules, A and B, forget appeals for the moment, and an amendment in 2003.
That's correct.
And do we know what the equivalent of for 5B then said?
Yes, Lord, it was Rule 2.4 of the Legal Aid Defence Certificates Rules 1966.
Previously, Rule 2.4, yeah, as amended or not?
I don't think that was amended, my Lord, but we'll check that.
Yeah.
But it provided that where the charge is one of murder, or the case appears to present exceptional difficulties, a certifying authority may certify that, in its opinion, the interests of justice require the person charged shall have the assistance of two counsel.
It just said two counsel, same language.
Yes, my Lord. It didn't define what exceptional circumstances meant.
No.
But it was in substance the same test.
What was the title to those rules?
That was the Legal Aid Defence Certificates Rules 1966. So those are the rules, my Lord, which are referred to at Regulation 8.1b.
So significantly, these rules that we're now looking at, whatever may have been said in the correspondence from the Minister, do not represent a change of language.
Are the costs rules the ones at 639 in the paper bundle?
My Lady, those are we've called the costs amendment rules
Yes.
in 2011. They amended the 2005 rules, which the court will have at page 561 of the paper copy.
So are these the rules that were in discussion? You were asked about the correspondence and to what it related. Is this the document that part of it related to? The only reason I ask it is because there is reference in here to leading junior counsel.
Yes, there is, and we accept that in the costs provisions, there is reference to leading junior counsel. And the case that we've made is that that simply reflects the fact that under the Bar Code, in exceptional cases, there can be a leading junior counsel.
Yes, but I'm not so much interested in the Bar Code at the moment as in the other regulation.
Well, it might be that the court would take the view that the cost rules can be used as an aid to construction of the 2012 Defence Certificate rules.
What date are they?
These are the 2011 rules.
But the previous rules had the reference in as well, didn't they? The 2005 rules. So they all, it's a theme, I think.
I think that's right, my lady. We don't have the unamended version of the 2005 rules.
Oh, right, I see.
So the copy that the court has, beginning at page 561, is...
I've got it. It's the same thing.
It's the amended
As
rules.
amended.
I'm sure we can find for the court a copy of the as enacted version. So there is a point, I accept, a new point about the interpretation of Regulation 4.3. If the result of Regulation 4.3 is that in a two-counsel case, the requirements of the Defence Certificate rules is that a senior counsel and a junior counsel must be instructed. Again, that's the end of my learned friend's case. We don't need to go any further. So any of the submissions that I make hereafter assume that point against us. If the court will keep volume 1 open and turn to page 615 in the paper copy, 614. One imagines in the electronic copy. This is Article 15 of the 1981 order. I'm going to take the court to Article 15 and Article 36A3 of this order, but I remind the court this is meeting my learned friend's objection that none of this has anything to do with the Bar Council. They have no role at all in saying who should or should not be instructed or available to be instructed. Now, Article 15 is in Part 2 of the 1981 order. It's dealing with civil legal aid, so it's not directly relevant for present purposes, but we'll see that the same approach is taken in criminal cases. But 15.1 says that any practising barrister, of course that's a barrister permitted to practice under the Bar Council's code, any practising barrister shall be entitled to give advice or assistance or to act for persons receiving legal aid unless he is for the time being prohibited from doing so by any determination of the General Council of the Bar of Northern Ireland or by any determination of a disciplinary committee. We say that plainly includes a determination imposed or included within the Bar's Code of Conduct. The Bar Council has power to determine that a barrister is prohibited from doing certain types of work. The equivalent provision on the criminal side is set out in Article 36A, and the court will find that in the paper copy at page 626. And the court will see that this is a provision dealing with the assignment of solicitor and counsel. And 36A1 says rules under Article 36(3)(b) must provide that, and then this is an important phrase, subject to paragraphs 2 and 3 and to any provision made by virtue of paragraph 4, a person in respect of whom a criminal aid certificate has been granted may select any solicitor or counsel willing to act for that person to be assigned so to act. So this is statutory recognition of the right of choice, which is included within Article 6(3)(b) of the, or 6(3)(c) of the Convention. But the statutory effect which is given to that is expressly subject to paragraphs 2 and 3. It's paragraph 3 which is relevant for present purposes. It says, a counsel shall not be assigned, that is to say, cannot be briefed, in pursuance of a criminal aid certificate, if the counsel is for the time being prohibited from being so assigned by a determination of the General Council of the Bar of Northern Ireland, or by any determination of a disciplinary committee. Then 4.4 provides that the department can itself, if it wants, make by regulations further detailed provisions restricting the right of choice. Quite a curious provision in 36A7, which suggests that a solicitor or counsel who's been selected to act for a person may select another person to act for that person as the agent of the solicitor or counsel. So if you do select your counsel or your solicitor, according to this provision, although this isn't an issue in this case, they can simply pass the case to someone else, and that's permissible within the terms of the regulations. But the point for present purposes is the right of choice is statutorily protected in 36A1, expressly subject to the power of the Bar Council to determine that a particular counsel should not be entitled to act in a particular case or a particular class of cases. So, my learned friend's suggestion has nothing to do with the Bar Council. They have no constitutional competence here. Statute doesn't mention them. What are they doing? They're a private organisation. With respect, in light of this provision, that case falls flat. Constitutionally, under the terms of the legal aid legislation upon which the appellant relies, the Bar Council is entitled to determine that counsel shall not be assigned in certain cases. Now, in fairness, I have to make a point as to when this particular provision came into force. So the court will see the annotation just towards the bottom of the page that this particular provision was substituted by a 2014 Act and came into force in mid-2015. But in our submission, what this provision does is simply recognise the long-standing practice as it had been and as it had been accepted both by the Department and by the Legislature. A further point on that arises from the Access to Justice Northern Ireland Order 2003, and the court will find the relevant provision of that at page 631 in the paper copy, 630 electronic. This again is dealing with legally aided cases. And Article 35, paragraph 2 of the 2003 order provides that the Commission, this is the Legal Services Commission, shall not fund any civil legal services or criminal defence services, that's this case, provided by a barrister who is, for the time being, prohibited from providing such services by any determination of the General Council of the Bar of Northern Ireland, or again, by a determination of a disciplinary committee. So we say plainly, a counsel can't be assigned pursuant to a certificate if the legal aid provisions governing payment say that they can't be paid. Yet again, the power in this field is circumscribed by the availability of the power on the part of the Bar Council to make determinations as to who should appear in what cases. The regulatory powers of the Bar Council are also recognised in 35.3, which includes the fact that the Commission can make a complaint to the Bar Council about the provision of criminal defence services by a barrister. And then I asked the Court as well to note in particular Article 35.4, which is of significance. Any right conferred on an individual by virtue of this part to select a person to provide criminal defence services for him, so this is the right of choice, and that's contained in Article 30 of this order, which is expressly subject to Article 35. But any right of choice shall not prejudice the law and practice relating to the conduct of proceedings by a solicitor or barrister. So the right of choice is without prejudice to not merely the law, but the long-standing practice in Northern Ireland, which in our submission plainly incorporates the long-standing rule of conduct since 1979, that in two council cases, save exceptionally, one must be senior. But on the basis of these provisions, we say it is clear beyond doubt that the legislature has invested the Bar Council with a role in this field, where the Bar Council makes a determination which affects who can or cannot be briefed, who can or cannot be assigned, who can or cannot be paid. That has, taking the convention language, not merely some basis in domestic law, but a crystal clear and unchallengeable basis in the very legal aid provisions upon which my learned friend finds his case.
Good. Well, that's a convenient note on which to suspend operation. How much longer will you be, Mr. Schofield? Half an hour?
No longer, my lord.
Yes.
I'll do
good.
my best.
See you again at 2 o'clock.